This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Let him start, please.
Yes, kindly come to, let us, we are concerned with the compliance of Supreme Court judgment. I shall paste that also, but kindly come to the notification. Page 53. This is the advertisement seeking application for new selection, press selection.
Yes.
Now, in terms of every word is very important. 30th of May 2025. In terms of the judgment and order of the Honorable Supreme Court. Therefore, this is not an independent selection process by the School Service Commission. Order of the Supreme Court in Civil Appeal number so-and-so, read it in MA. I shall also place the order passed in MA. The West Bengal School Service Commission has been directed to initiate fresh selection process to the post of assistant teacher for 9-10 secondary so-and-so. The Commission and the government of West Bengal have already applied for review of the said judgment and order, and is exercise strictly subject to the outcome of the review. Review were dismissed. The notification is being issued for conducting second SLST for selection to the post of assistant teachers of class 9, 10 in secondary, higher secondary, and to the post of assistant teacher in 11, 12. So-and-so schools in West Bengal against the, underline this one, is very important, against the vacancies to be filled, directed to be filled up by initiating fresh selection process. And further vacancies, this is really intrusion to the Honorable Supreme Court judgment. Further vacancies as may be received from the West Bengal Board of Secondary Education under West Bengal School Service Commission Selection Appointment Rules 2025. When the Supreme Court delivered the judgment, there was the existence of 2025 rules. Therefore, if you say that you are conducting the selection in view of the Supreme Court order, you are really diverting and violating the Supreme Court direction. That's why the Supreme Court last order said that whatever order you have passed, that is to be considered, not any subsequent observations or opinion. The entire process is being carried out strictly without prejudice to rights and contentions of the state, commission and the board in their pending review petitions. Honorable Supreme Court Engineer so-and-so, the commission, I am not troubling my life with that. Then the selection process will be governed by the School Service Commission Act 1997 and subsequent amendments to Rules 2025 and the relevant NCT and state government guidelines. Then my lord will turn over, I am not troubling my lord with this. Kindly come to clause 2. Eligible candidates with minimum qualification laid down in 2025 may apply online through the official website so-and-so. Therefore, you are now undertaking process under the Rules 2025 with the eligibility clause. This is the initiation. And therefore, you prescribe the eligibility clause. Very important. Then, kindly will not turn to next page, clause 7. Manner of selection. Selection to the post of teachers for 9, 10, 11, 12 in school shall be made, without kindly underline this, on the basis of written examination, evaluation of qualifications of the candidates, oral interview, and lecture demonstration to be determined by the commission. Therefore, the area of selection is specified. I repeat, written examination, evaluation of qualifications of candidates, oral interview, and lecture demonstration. There is no scope for any other element to be incorporated, which they sought to incorporate the so-called teaching experience. The advertisement does not make any room for that. Then preparation of panel. After evaluation of the OMR sheet, answer sheet of the written examination, the Central Commission shall prepare and publish in their website details of all candidates to be called for interview, strictly in accordance with preliminary merit score category-wise on the basis of the rules 2025. Now, these are the important areas I will not point out to your lordship to show that you are inviting applications through an advertisement, giving the detail how to contest and what should be the methodology. Then kindly turn to page 56. Good. Age limit shall be considered on the basis of age as of 1st January 2025. The age relaxation will be given to the candidates who have been given the benefit of age relaxation as per order dated 3rd April 25 of the Honorable Supreme Court. Provided further that a person who comes under more than one category shall be eligible for only one benefit of relaxation which shall be considered most beneficial to him. Then next page note. Qualifications obtained on or before the last date of receiving online application mentioned in the application form shall only be counted for academic and professional qualification. Then the tentative schedule. Now this is the advertisement, and this advertisement below seems to be in accordance with the constitutional principle of Article 14 and 16. You invite all. Now kindly turn to the rule 39. At page 39. Now, this is without prejudicing my fundamental point that you have started this selection process in terms of the Supreme Court order, you say, and Supreme Court order which was passed, there was no 2025 rules. Though it's not recorded, latest observation of the judges are very clear. And that's why I say that only the final order should be considered, not the subsequent any opinion or orders. Here, Lordship, kindly come to this 29th of May 2025 is the publication of rules. And the publication of advertisement was on the 30th May. Well, just please notice. Kindly turn to page 40, the interview list. Interview list in respect of SLST means in case of vacancies in the post. In respect of means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category-wise on the basis of the preliminary merit score. That is a score from written test and TET and academic score in the ratio of 1.6:1. Now this has been reflected in the advertisement. Then merit list in respect of SLST means in case of post, a list of candidates prepared category-wise on the basis of merit, which shall mean in addition to what has been stated in Rule T121K, marks obtained in oral interview, lecture demonstration, prior teaching experience. This is the incorporation by which our allegation, we are freshers, by which you wanted to give credit to the appointments which were set at naught, declaring void by the Constitutional Court. This is without malice in law.
Page 40.
You had never declared in the advertisement that there will be scope of any prior teaching experience. Now you incorporate this. Now kindly come to again, my lord, the rules in the schedule. Now, kindly, before that, Lordship may turn to page 42. Rule 7, information regarding vacancies. The Commissioner of School Education shall, on being intimated by the West Bengal Board of Secondary Education, as and when deemed appropriate by the board, prepare a vacancy statement of assistant teachers, and with the approval of the state government, send same to the board. The board shall, with prior approval of the state government, send a category-wise vacancy report. Now, the first question, if the rule is promulgated on 29th of May, advertisement is made on 30th of May, when did the board undertook this exercise to identify the vacancies? But it is humanly impossible that you could identify the so-called extra vacancies.
Yes.
Then the report, as mentioned above, shall be sent to the Central Commission in the following manner. Firstly, before the date of publication of the advertisement inviting application, there shall be termed as indicative vacancy. And finally, before the date of publication of the interview list, there shall be termed as final vacancy, which may increase or decrease in comparison to the indicative vacancy. The indicative vacancy, my lord, is the vacancy which would be arrived at after exercise of Rule 7, and that will be intimated. Lord Lordship will definitely ask for production of the records to show. When did the exercise under Rule 7 was undertaken by the board to intimate the vacancies, which prompted the authorities to advertise very next day, 30th.
The daily list, 19th to 38.
Now, these are all stage managed, therefore I say. Now, kindly come to me, Lord, the rules schedule.
This is going to that is going to was right.
At page 49.
Yes.
Selection to the post of assistant teacher and so and so. Now, I just take your lordship to the relevant portions. Written examination OMR will be 60 marks, but which is in variance with the 2016 rules. I shall paste that also. Educational qualification 10 marks. Here also, my lord, will be pleased to note, I will demonstrate that the assessment nature has been varied from 2016 rules. Based on marks of graduation, post-graduation subject for which applied up to this level playing field. Then, prior teaching experience 10 marks. At the secondary level in a government or government aided or a government sponsored school, calculated on the basis of 2 marks for each year of service in substantive post as permanent or on contractual basis. Oral interview 10 marks, lecture demonstration 10 marks. Apart from this prior teaching experience, all other things, Lord, I would say, of the level playing field. All have the same benefit. This prior teaching experience is a new incorporation to ensure that these candidates, I do not give any adjective, whose appointments were cancelled, declaring void. Not some irregularities, therefore I cancel it. It's a void. They have to be given the benefit. That is the reflection here. Now, my lord will kindly take to 2016 rules. Because they say that this is because of the Supreme Court judgment. Now, 2016 rules is 346. Kindly will not count to 348. The qualification that it really in fact starts from 347.
Only the freshers.
Name of post qualification and age.
That's what happened. Yes.
The appointment of persons to the post mentioned in column 2 of Schedule 1 shall be made by selection, that is direct recruitment. Well, this has also some bearing of service jurisprudence. They meant to say this is not a promotional post, direct recruitment, therefore everybody will enter through the same channel having same competitive qualification. Name of post so and so, that provided that the qualification of teacher includes academic qualification and professional qualification of teachers for 9-10 as notified by NCTE from time to time applicable on the date of advertisement. Provided further that the certificates obtained on or before the last date of receipt application as mentioned, application shall be counted for academic and professional qualification. Well, I am not troubling with the age limit.
347.
So for the proviso is there for the teaching and non-teaching staff, then kindly come to that additional essential qualification of candidate. A candidate willing to be selected as teacher for class 9 and 10 of any school having Bengali or English and so on, they have to have the language preference. A manner of selection. Selection to the post of teacher of 9-10 shall be made on the basis of the results of the state level test, comprising written examination conducted by the Central Commission, evaluation of academic and professional qualification, and personality test of the candidate in the manner specified. But there was no scope for any professional qualification. And also kindly come to the schedule of these schools. At page 352. Select the part A, the others are not disputed. Selection to the post of teachers for 9-10 in school shall be made on the basis of written examination, evaluation of qualifications of the candidates, and personality test to be determined by the commission in the following manner. Written examination, academic qualification, personality test. No professional experience. Sorry, the prior teaching experience. Then the part B, but similar. I'm not just troubling my lord with these similar things. Well, different qualification, 9-10, like that. And part B is also important. Here, my lord, how the best persons would be chosen for teachers category, there is a rationale, part B. Provision relating to evaluation of academic qualifications. It starts from school final Madhyamik. Full marks 10. If you have 60% above, how the marks would be distributed. For the higher secondary stage, then Milord, graduate stage, postgraduate stage. Therefore, your entire career is being assessed for selecting the best out of the lot. With 25 rules, Milord, these are gone. Just turn to page 49, my lord, you find here this assessment of continuous academic career gone. Page 49. Yes. Schedule 2, I had placed written examination 55, it was modified anyway, but then how the educational excellence should be assessed based on marks of graduation or post-graduation, or no that. The other career, whether you had just passed through Madhyamik, somehow higher secondary, which are taken note of assessment, now is removed. only graduation and post-graduation. The intention of making this rule is to again give a leeway to those persons whose appointments are cancelled. Why? Now these are the rules. 35. Now I will trouble Lordship to come to the Supreme Court judgment. Because the Honorable Supreme Court says you have to strictly go by the judgment which you had delivered. That judgment starts at
Page 60.
page 60. Go to 60. But, excuse me, Miller, I would take the trouble to read the judgment in its entirety, if Your Lordship permits me.
It's entirely.
The impugned judgment, that is the High Court judgment, Division Bench judgment, at page 60, dated 22nd April 24, en bloc, set aside the 2016 selection process conducted by the School Service Commission, so and so. The appellants before us are the selectees, some of whom have been working over 5 years. They fall into two categories: selectees with purported evidence and material including wrongdoing. Other selectees who claim that they were validly selected and have committed no wrongdoing. State has also challenged. Now kindly come to the relevant portion. Para 20, illegalities in the selection process. At page 77. In our opinion, this is a case wherein the entire selection process has been vitiated and tainted beyond resolution. Entire. Manipulations and frauds on a large scale, coupled with attempted cover-up, have dented the selection process beyond repair and partial redemption. The credibility and legitimacy of the selections are denuded. High Court has referred the illegalities. I am not troubling my lad, but the Supreme Court's opinion is at the very beginning of this 8th paragraph. Then kindly will come to the directions.
45, 90, page number 98.
Kindly turn to page 98, the conclusions. The last question relates to the relief. Whether it requires any modification, we find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated and they should be required to refund any salary payment received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. Till date, my lord, the tainted list has not come out. The tainted categories have been defined by the High Court, upheld by the Supreme Court. That I shall place later. For candidates not specifically found to be tainted, their entire selection process has been rightly declared null and void due to the egregious violations of the illegalities which violates Article 1416. Null and void. No person of that category can claim that I have an experience. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute any payments to them. Their services will be terminated. No candidates can be appointed once the entire examination process results have been declared void. No candidates can be appointed. This is the Supreme Court's clear verdict. Then, Lord, Next, some of the candidates, appointed candidates, who do not fall within the category of tainted candidates may have previously worked. May I give a little background of this? Some appear says that we were properly appointed, we were working in different institutions, maybe primary teacher. But we thought we have a better opportunity. Since this recruitment goes, kindly restore that old recruitment where we are not tainted. And that appointment is never questioned. The Honorable Supreme Court, my Lord, out of his grace, gives this direction. I am reading. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with autonomous bodies. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. Nothing to do with this teacher's profession here. These applications must be processed by the respective departments within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of their previous appointment, their joining will not be considered a break in service. Their seniority, other entitlements will be preserved, and they will be eligible for increments, so and so. Therefore, this is completely a separate category. Few who had earlier had a regular appointment, the Supreme Court very well go back. Then lastly, we address this case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment had held the appointee, Ms. Soma Das, shall be allowed to continue on humanitarian grounds. While we will not interfere with this finding, Soma has made an exception. We make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. However, in consideration of the disability, these candidates will be permitted to continue and receive wages until the fresh selection process and appointments are completed. Again, a special category. Very well, you continue till fresh. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required, with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate. Therefore, my Lord, the disabled who are not specifically tainted, they will be allowed to participate. This logic on the last occasion, the Supreme Court accepted. Supreme Court said, read it similarly. Not that tainted disabled should be allowed to participate. Our observational findings will not influence the criminal proceedings. Accordingly, we afford the impugned judgment cancelling en bloc entire selection process, but have made certain modifications in direction issued by High Court. The appeals are disposed of. Now, after this, government Miller takes out a miscellaneous application. No, application the good. Well, I just placed the application also. I have to cross-title it. I just play, yes. Anyway, let us come to the order on their application, page 107. We are inclined to accept the prayer in the present application insofar as it relates to assistant teachers for class 9, 10 and class 11, 12, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid posts shall be published before 31st of May 25. This is on the application of the state, the board. They made an application, the copy of the Lordship, that the school's running would be difficult. Please allow some of the teachers to continue to see that the education is not affected. The Honorable Supreme Court said very well, only for the so-called untainted candidates till 31st December. In the meantime, start recruitment process of the aforesaid post. And that application of board below is at page 249. Yes, this is also important to place. At page 251,
No, the PDF.
the instant application is being filed by the applicant seeking issuance of appropriate direction on this code pursuant to the final judgment and order dated 3rd April 2025. Therefore, they accepted that the judgment has reached its finality. If the appellant is an independent statutory body, so and so, I'm not telling that. Then paragraph 3, the appellant had challenged the final judgment and order dated 22nd April passed by the Calcutta High Court, and that was dismissed. Then they go to the directions of the Honorable Supreme Court. Then kindly come to paragraph 6. By way of the instant application, got it?
Yes.
By way of the instant application, the appellant most humbly craves to seek appropriate directions or modifications of the judgment to permit the appointed candidates not found to be tainted, their own admission, to temporarily continue in various schools without claiming any equity in their favor until the end of academic year or until the process for fresh appointment is concluded. The fresh appointment will not is pursuant to the direction passed by the Supreme Court 30th April. Supreme Court fill up these posts. Therefore, they admit this. And on such application, their prayer was the prayer was at page 260. Their MA application. The permit the appointees not found to be tainted to continue in service till the end of the academic year until the process of fresh appointments to such post is concluded, whichever is earlier. On that, the Honorable Supreme Court passed this order at page 107. It's very important. An advertisement for fresh recruitment shall be published before 31st May because they say that we want to carry on the fresh recruitment process. The examination and the entire recruitment process shall be completed by 31st December 2025. Now, kindly will not take note of the direction of the Supreme Court that advertisement shall be published by 31st of May for the posts which were found to be illegally appointed by the Supreme Court. On 31st of May, 30th May, they issued the advertisement. 29th May, they issued notification of fresh rules. I would again say, the entire chain of action reflect the malice in law. Then the state governments, this is very important. Supreme Court was so skeptic about their behavior. The state government, the applicant, that is board, and the School Service Commission shall file, nobody could not subsequently escape saying that I did not do it, shall file their respective affidavits by 31st of May, enclosing therewith a copy of the advertisement for the fresh recruitment as well as the schedule therefore, so as to ensure completion of the recruitment process by 31st December. In case the advertisement is not published, the affidavits are not filed, the appropriate orders will be passed by this court, including imposition of post and vacating of the order. In fear of this, it was done on 30th. Then this is important. We clarify that these orders shall not be read as conferring any special right or advantage on the apostate teachers, in so far as the fresh recruitment process is concerned. Therefore, without this continuation, even for a limited period, they cannot take any advantage there because the entire thing was void. Supreme Court was very much not conscious of this prayer. Then we are not inclined to accept the prayer in the present application insofar as non-teaching post group C are concerned, as the number of appointees specifically found to be tainted in this age group is substantively high. And secondly, what was prompted to us to pass this order in respect of assistant teachers not found to be tainted is that the students undergoing study presently should not suffer on account of the lack of teachers. Now, your Lordship has been pleased now to take note of this judgment, and Supreme Court says any observation you have made after our final order should not be taken note of. Here, the final order says everything is void, and then on their place says you allow them to continue for those posts without conferring any benefit to them. In this background, 25 rules I have placed, that the purpose was to confer them the extra benefit, which is in total disregard to the Supreme Court judgment. And that's why the Supreme Court very categorically, if I may again take back to your Lordship, says, since my Lord's various orders were noted, these were flagged. The third page, the High Court shall examine the matters uninfluenced by any of the observations on merits made by this court in the orders passed after the decision in Boishati Bhattacharya Supla. Therefore, the decision is conclusive. You cannot go beyond that. Now, my Lord, these rules, according to my submission, my Lord, is ultra vires to Article 14 and 16.
You are appearing for the freshers.
I am appealing for the freshers. And Lord, the advertisement invited. We are invited that this is the process of selection will be done. Now we find in the rules you have made such a provision which makes us almost impossible to contest. No level playing field. In that background, this violation of the rule is challenged. And if your Lordship is with us, then my Lord, one chapter is closed. You have to do afresh. And if your Lordship do not agree that this rule is not ultra vires, then my submission is that even the application of rules is made in such a manner to give illegal benefit in violation of that rules. These are the 2 points. Now, so far the violation of the rules is concerned, my Lord, may I just take your Lordship, my Lord, to the authorities. রাখো আমি একটা করে দেখাই ছটপট না করে
জিজ্ঞেস করো না তুমি কি করতে পারো অনেক
সাইড করে I take your Lordship statement to the latest judgment of the Supreme Court in Assam versus Rava 2025 volume 7 SLST 705. The judgment is delivered by Justice Dipankar Datte. এখানে আরে এটা তো অন্যটা 25/7 SCC দেখো আছে
আঠারো নম্বর
সিরিয়াল নাম্বার আমার বই আমার বইটা কোথায় serial number.
What are all these? These are judgments.
Judgment compilation, serial number 80.
Serial number 8.
18. 529 to 550.
529 to 552.
Judgment এই একটা কম্পাইলেশন দিলেও নয় ইন্দাকে
Give the first pages only the references. You are not required to give the history of judgments.
State of Assam versus Aravind Rava 2025-7 Supreme Court cases page 705.
ইন্ডেক্সটা দিলে তো কথা ইন্ডেক্সটা দিয়ে দিলেও আমরা ফলো করতে পারবো ইন্ডেক্সটা
হ্যাঁ
ইন্ডেক্সটা দিয়ে দিচ্ছি
Now, the relevant paragraphs would be, kindly will not turn to paragraph 39. Now, the issue was whether in absence of statutory rules, by administrative order, appointments could be done. The Supreme Court was considering, yes. Joshua, the page bol daw na to.
39.
Paragraph 39.
Yes, paragraph 39.
It cannot be gainsaid that the factors of when, which, what, who, and how that are associated with the recruitment or selection process is the prerogative of the recruiting authority and the selectors. However, at the same time, the process has to be conducted consistent with the statutory provisions governing the same, if any, as well as principles of absolute fairness and complete non-arbitrariness. Though it is true that law does not postulate a fetter on the authority of the employer, state, and is within the domain of the government when to initiate a process of recruitment for public employment, either according to recruitment rules or even in absence thereof, it is for the government of the day to decide in which manner it proposes to conduct selection. What would be the various stages the candidate aspiring for appointment have to pass through in order to be placed in the select list? Who would be selectors and how weightage is to be given to each of the testing methods? A great deal of credence is lent to a process if it is fairly and transparently conducted in accordance with rules. Whatever be its source, without the slightest hint of any bias or favoritism or nepotism, normally it is not for the courts to interfere unless the process smacks of malafidis, that I have already tried to develop this point. However, the right to be considered for public employment being a fundamental right, it would be safe and prudent to have a recruitment rules to govern the process of selection so that the best possible talent is appointed in public service. Obviously, assessing the merit of the candidate aspiring for public employment on the basis of a prescribed standard would not only provide a level playing field for each of them, the excellence of an institution to which the appointment is made would depend directly on the proficiency of its number of staff, and that would in turn depend on the quality and merit of those who offer themselves for selections and ultimately get selected, necessitating the selection to be conducted within a hidden taint or masked malafidis. Last but not the least, having regard to present times when corruption has been held to be a work of life by certain responsible citizens of the country, it would have been desirable if the process of recruitment of 104 constables were conducted after framing recruitment rules and also prescribing a written examination to keep the process absolutely above board. What the principle is, there must be a level playing field. And you have destructible thinking with a malafide intention. I have said, Lord, the malafide intention is not at all personal malafide, but malice in law is also malafide. This is the latest judgment, and another judgment will have to show whether any preference can be given at the time of initial recruitment, 1995 supplementary to SCC. Supplementary to SCC, page 235. Entry 70. Right there, 32.
राहुल पाटिल शिक्षण एक
रेफरेंस तो
We'll all learn more law.
आगे जॉर्ज साहब के दाओ उधर पढ़ देंगे.
Gives us opportunity to learn something.
This is three judges bench order 1995 supplementary to SCC.
Yeah. Got it. Thank you, Mike.
That's got it.
Yes.
Kindly turn to paragraph 13. Let me start from paragraph 11. We shall now briefly refer to the main grievances voiced by the learned counsel for the respective parties in connection with these two GOs. It was submitted by learned counsel appearing for non-Telugu speaking candidates that when a direct recruitment is appointed to any public service, maybe in the lower echelon of service, like Group 3 and Group 4 posts, which may consist of clerical posts, merit should be the criteria which the Public Service Commission should follow. If a candidate satisfied the basic requirement of eligibility for competing in such public recruitment, provision of such weightage of 5% of marks to Telugu medium candidates would only per se be arbitrary and discriminatory, and would be destructive of the concept of selection on pure merits. That even if Telugu be the official language as adopted by the state in the light of linguistic policy, once a candidate is recruited from the open market as per the relevant rules, before he is confirmed in service and before he is entitled to earn an increment in service, he is required to pass the Telugu language examination. This completely meets the requirement of the department that the candidate must be having working knowledge of Telugu to enable him to converse and correspond in Telugu with members of the public as well as the other government departments. This satisfies the object of securing efficiency administration. To put a further fetter at the entry point, now this is vital, by giving a special weightage of 5% marks on the aggregate to candidates who have passed their graduation examination Telugu medium would therefore have no real nexus to the object sought to be achieved and would be counterproductive, as more meritorious students, even though having secured more marks in the aggregate in the competitive test, would be elbowed out by those standing far behind in the queue only on the specious plea that they have passed the qualifying examination Telugu medium. But here the fact is so glaring. The fresh candidates even secured 100% marks on merit were out of competition because of 10 marks. That even these candidates who have passed qualifying graduate examination English medium or any other medium in the state have to appear compulsorily in one of the paper of Telugu language. Therefore, he is also having sufficient working knowledge of Telugu to enable him to correspond in Telugu as required by the exigencies of service. That when under the relevant recruitment rules for the post concerned, the minimum educational qualification prescribed is passing of graduation in any subject, the further question whether he has passed this examination in Telugu medium or English medium would be totally irrelevant. That if a candidate who has passed graduation examination in English medium cannot be told of the gets and can legally compete in the examination for recruitment to the public post advertised by the Public Service Commission, such imposition of 5% weightage of total marks in favor of candidates who had passed qualifying examination of graduation in Telugu medium would amount to imposing an additional qualification or eligibility criteria which is dehors the recruitment rules, and would result in total arbitrariness and would amount to give a discriminatory and hostile treatment to all candidates who otherwise are qualified to contest but did not have Telugu medium at their graduation level. Well, if I may put my facts here, the language would be that the persons who are otherwise qualified to contest but did not have teaching experience will be out of consideration. It was also submitted that the object about maintaining the efficiency of the administration can also be achieved by providing or prescribing for one more paper in the competitive test on Telugu language itself, as in that eventuality all the candidates competing for examination will have an equal chance to compete for the state examination and show their proficiency in the subjects concerned in which they are examined. For all these reasons, it was submitted that the decision of the tribunal is quite correct, and similarly the decision rendered by a single judge of the High Court, as he then was, is equally correct, and the division bench judgment which overturned it deserved to be set aside. Now, the relevant paragraph 13, I have given the factual background of that. We have given our anxious consideration to these rival contentions and have reached the conclusion that the impugned government orders and the consequential statutory rules framed under Article 309 Proviso do not stand the test of Article 14 and 16 of the Constitution and will have to be declared invalid The reasons for our aforesaid conclusions may now be catalogued as under. 1. It has to be kept in view that recruitment to public service through the Public Service Commission is an open recruitment where any eligible candidate is permitted to compete on a par with other competitors. The minimum eligibility criteria for recruitment to such post is graduation. Therefore, it does not mean that candidates who have passed their graduation in non-Telugu medium cannot compete for the said post. It has to be noted that the minimum educational qualification for appearing at the selection is graduation simpliciter. But kindly just go back to the advertisement, minimum eligibility criteria. If the object or underlying the intuned provision of weightage of marks on the aggregate to candidates who have passed their graduation in Telugu is to permit candidates knowing Telugu language to occupy the post concerned, then it cannot be said that merely because a person has passed his graduation in Telugu medium, he alone will be proficient in Telugu and not the candidate who has passed his graduation in any other language. For appointing persons to post in public services through direct recruitment, the criteria has to be pure merit. Therefore, all candidates who possess minimum educational qualification have to be assessed on the basis of their relative merits. At that stage of assessment, if 5% more marks in the aggregate are added in the assessment of candidates who have passed minimum educational qualification through Telugu medium, the very criteria of relative merits would get frustrated and would become assured. In this connection, we may usefully refer the decision of this court in case of Pradeep Jain versus the Union of India, but I am not really reading the quotation from the other judgment. Then we will kindly skip over, come to this paragraph. It is of course true that aforesaid observations are made in connection with the admission in MBBS and postgraduate course, and in the light of the question whether discrimination on the ground of place of birth would be countenanced under Article 15(1) and 2. However, the sweep of Article 14, read with Article 16(1), is no less pervasive. Article 16(1) ensures equality of opportunity for all citizens in the matter of employment or appointment to any office under the state. Article 14 declares that the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. The principles emerging from Article 14 and 16 are well settled. The object is to ensure equality to all those who are similarly situated. In other words, all the citizens applying for employment under the state are entitled to be treated alike. If that is so, it is difficult to appreciate how, having once allowed all candidates having minimum qualification of graduation in any medium to compete for the post, a further special beneficial treatment can be given to only candidates passing minimum educational qualification examination, namely graduation in Telugu medium, after their relative merits are assessed vis-a-vis other candidates in open competition. The similar is the provision here. After all things, then you get 10 marks. Reliance placed by learned advocates for the state of Andhra Pradesh and Telugu medium candidates on the decision of this court in the case of Sanjay Halwat is of no assistance, as on the peculiar facts of that case, the court held that weightage of 10 extra marks to the candidates who have graduated from medical college at Rohtak was not discriminatory or violative of Article 14. In that case, extra marks were found to be justified but awarded to local medical graduates for the purpose of ensuring that the medical facility in the state is not impaired in any way because of dearth of doctors. In order to attract residents of Haryana to postgraduate courses after they obtain medical degrees, this weightage of 10 marks was found necessary and reasonable. That was to ensure for the people of the state services of good doctors hailing from Haryana itself. It was also found that this weightage was based on domicile in Haryana or education at the Medical College Haryana. This does not have the effect of shutting the doors of admission to the outstation boys. The aforesaid weightage of 10 marks was therefore justified on the peculiar facts of that case before the court. Such is not the situation in the present case. The aforesaid subclassification on meritorious candidates into Telugu medium candidates and non-Telugu medium candidates, insofar as the graduation is concerned, does not have any rational nexus to the object sought to be achieved thereby. If the object is to have a proficiency in Telugu language, which is the official language of the state, it has to be kept in view that even those candidates who have studied in non-Telugu medium like English or Hindi at graduation level also have to pass one compulsory paper of Telugu. It may be pointed out that the state had adopted, after passing the Official Language Act 66, three-language formula in the field of education. The students studying in other media are also required to pass a paper in Telugu language. Therefore, they have got working knowledge of Telugu. It has also to be kept in view that even after they are appointed to the post for which they compete, they have to clear the language examination before getting increment or even confirmation. And if they do not clear the examination, they are liable to be discharged. If that is so, proficiency in Telugu language at entry point pales into insignificance. So far as the recruitment to this post are concerned, it may be that the selected candidates concerned lower echelon of service may have to deal with public in Telugu or may have to correspond with other public departments or authorities in Telugu language, but that is well ensured by the acquiring or passing Telugu language examination after being recruited to the post. Under these circumstances, giving a further weightage of 35 or 40 marks to such candidates even prior to their entry in service has really no nexus to the object sought to be achieved by such provision. It cannot be said that merely because a person has passed his graduation in Telugu medium, he alone is proficient in Telugu and not the candidate who has passed his graduation in other language. There may be cases that I am not just troubling my lord reading the entire thing, then kindly come to the conclusive decisions. For all these reasons, it must be held that the present rule of weightage to be given to a candidate who has passed graduation in Telugu is violative of Article 14 and 16 of the Constitution and does not represent any valid and reasonable classification having a rational nexus to the objects sought to be achieved. Now, with another judgment, my lord, this is a three judges bench again. 2005, volume 13 SCC.
ওইটা ভলিউমে নেই, এটা ভলিউমে নেই,
এটা ওখানে নেই,
এটা নট
ওটা আমার ইন্ডেক্সে নেই না, ওটা পরে দেওয়া আছে
পরে
কত
2005 13 SCC 721 2005 13 SCC 2005 13 SCC 721 722
Paragraph 11. Taking our findings as made herein earlier to the extent that the writ petitioner was entitled to sit and write the examination for selection of probationary officer in the bank, let us now proceed to consider whether the writ petitioner would be entitled to appointment in the post of probationary officer if successful in the written examination in view of the nature of the job to be performed as probationary officer. Before we deal with this aspect of the matter, we may take into consideration yet another aspect of the matter, namely, whether denial of permission to the writ petitioner to sit and write the examination for the post of probationary officer in the bank offence Article 14 and 16 of the Constitution. Article 14 of the Constitution guarantees to every citizen of India the right to equality before the law or the equal protection of law. The first expression, equality before the law, which is taken from the English common law, is a declaration of equality of all persons within the territory of India, implying thereby the absence of any special privilege in favor of any individual. It also means that amongst the equals, the law should be equal and should be equally administered, and the like should be treated alike. Now, here all are at the entry point of teaching job, similar. Then how could you give additional benefit of earlier teaching experience, which under the law you cannot give? Because there was no experience, the appointments being void. And that what it forbids discrimination between persons who are substantially in similar circumstances or conditions. Yes. When similar circumstances, you have to sit for the exam, for job. It does not forbid different treatment of unequals. Article 14 of the Constitution is both negative and positive. Right, negative in the sense that no one can be discriminated against anybody and everyone should be treated as equals. The latter is the core and essence of the right to equality, and the state has the obligation to take necessary steps so that every individual is given equal respect and concern which is entitled to as a human being. Therefore, Article 14 contemplates reasonableness in state action, the absence of which would entail the violation of Article 14. Now, the paragraph 12 is also details discussion is made. I am not reading the entire thing. I will just only appeal to your lordship that kindly come to the 15 lines from the bottom. Under Article 16 of the Constitution, the general rule laid down is that there should be equal opportunity for citizens in matters relating to employment or appointment to any office under the state. The expression matter relating to employment and appointment includes all matters in relation to employment, both prior and subsequent to the employments. But I place this to show that what really Article 16 intends to carry forward for the principle of equality. Therefore, the Article 16 of the Constitution, what is guaranteed is equal opportunity to all persons. This qualification for recruitment to government service, and it is open to the authority to lay down such other conditions of appointment as would be conducive to the maintenance of proper discipline among government service. Like other employers, the government is also entitled to pick and choose from amongst a large number of candidates offering themselves for employment. But this can only be done in one condition, that all applicants must be given equal opportunity along with others who qualify for the same post. Well, I stop here. This is the basic principle. You are going for a public appointment. Teachers. They are not like any other job or profession. The teachers, they really create the nation. If at the end point of time they feel that we are out because we are not having some other qualifications. And what would the students feel? Nowadays everything is transparent. Now I find some teachers are crying that our students are not respecting us. Why would they respect? If they find that teachers have got appointment through illegal means. And Article 14, 16 has to be complied with strictly. And particularly in this case, I would repeat, the direction of Supreme Court was only to fill up those posts which fell vacant because of the judgment of the Supreme Court. And he wanted to amalgamate them. Now, this being the position, Milord, so far the key. Now that the question would come, I'm sure, that another writ petitioner, not this client, though I was the counsel, that's a different thing. Counsel doesn't have any cause. There, my lord, this writ petition was moved. Let us see what was the issue and how the court dealt with that. Division bench judgment. First of all, the principle is that I am not bound by the judge, with the best of respect. Definitely, they can not cite it as a matter of precedence. But the precedent depends on whether the points are good and decided. Now, this is settled law that even little bit of variation of facts, even one word, would completely change the ratio. Now, kindly take Rashaka down. This judgment of Orunimapad. Rashaka down.
আগের দিন দেওয়া
ছিল বললাম নাকি আর্গুমেন্টের সময় আমার কপি দাও কাইন্ডলি
সম্পূর্ণ একসাথে করা যেত page number 24.
Now, kindly come to Lord, page 2. The present appeal is directed against a portion of the impugned order, whereby the contention of the appellant that the recruitment process initiated in 2025 on the basis of the said rules of 2025 could not be made applicable to the present appellants as they are to be considered under the recruitment rules of 2016 was rejected by reasoned order. So this was the issue. While considering this issue, the Honorable Court categorically records that since the rules are not under challenge.
Page number 24, internal page 24.
Will not kindly turn to page 24, the paragraph 34 of the judgment.
Second saying of matter that you work on good matter.
That's very interesting. Kindly turn to paragraph 34. The awarding of 10 marks.
Yes.
The awarding of 10 marks is an weightage to be given on the basis of experience that is only expected that in selection process of this nature of kind, all the candidates are required to undergo the rigorous selection process. How the deepest of respect, court will not contradict itself. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks given to such candidates. So the first page says it should be considered contested by all candidates rigorous. And then section 10 marks weightage to given to such candidates. The object is to select and appoint an experienced teacher. That was not the advertisement. As rightly pointed out, Learned Advocate General and also Mr. Bandyopadhyay, appearing for the commission, that the writ petitioners are not coming within the purview of the categories in whose favor benefits and concessions have been extended. The judgment of the Supreme Court, they are not, extending paragraph 49 of the judgment of the Supreme Court, they are not candidates selected in 2016 recruitment process. In the meantime, they have not also applied for service in any educational institution. It shall be the duty and responsibility of state to ensure quality of education, and the eligibility criteria should be framed keeping in mind the interest of students. But eligibility criteria did not mention, even in the advertisement of the rules, that 10 marks should be given. If we accept the submission of so-and-so, then for the selection of the same subject teacher to different eligibility has to be applied. But deepest respect, this is just the other way. The eligibility criteria in the selection process 2016 is different from recruitment process 2025. Rules are more stringent and student-centric. The revision in the eligibility criteria is in accordance with the consonance with the NCT guidelines. Well, I fail to understand. NCT fixes their eligibility, minimum eligibility, nothing else. Anyway, therefore, here after considering all this, now the court says, when understood that this might lead to an incongruity, the court says next page.
That was previous.
The recruitment rules of 2025 has not been challenged by any of the appellants. No, I have challenged this. This petition has challenged this. Therefore, this judgment of division bench that will have no application even by the precedents in any way. Therefore, this judgment will not kind of stand in the way, and particularly after the last order of the Supreme Court, where the Supreme Court has made it very categorically that only the final judgment has to be considered. And final judgment says these are all void. And even on their modification application, Supreme Court says no benefit should be accrued to them. Therefore, if the 10 marks was open for all, then at the eligibility criteria it would have been said that you must have teaching experience. Yes. So that the other experienced people could have applied. But here also without well settled judgment of airing the transport costs. Whatever you declare, there was issue second grade hoteliers and third grade were given. He did not notify this. It becomes bad. In this background, I assure the rules is ultra-wise and should declare bad. And secondly, if dear Lordship, that is in item 25. But if your Lordship is not with me, then what would be the interpretation of rules? Kindly come to page 39 the rules.
25 to the
Now, Joshua, naam ka dita hobe na.
25 item.
You are referring to the rules?
Yes, yes.
It is here. So we can look at it.
এই চলে যান না আপনি কাজ পয়েন্ট বলতে পারবেন
26, 25.
25 rules
29 page
হ্যাঁ
এটার পেজটা
বলুন না
And then you followed by other advocates. May I have my answer?
ওটা ওইগুলো আসবো দেখাবো সব
Personal ground,
All right, all right.
I have to leave the court.
All right.
Thank you. Yes. I'll come back on Monday.
Yes.
So this is হবে না
এটা কি হইলো বলেছো ইয়েতে নেওয়া 25.
না তাই তো সেটা
সরকার লিখে সরকার
এই সময় তো তাহলে আবার কি দেখাবার কি আছে
পরে ওরা ওখানে সুপ্রিম কোর্টে
My Lord's order was specifically referred by the Honorable Supreme Court. Lordship is well aware. I need not really trouble my Lord with that. Therefore, the issues which had to be discussed are reflected and flagged in 7th November, 11th November, and 12th November, 19th November. I am really within the issues which was flagged by your Lordship. Now, kindly come to me, Lord, the rule against. Without prejudice to the argument by the other petitioner that this is ultra vires. Now, if Lord, some of the petitioners feel that if ultimately the rule is upheld, then what would be this?
These set of petitioners are also freshers?
Yes, 25 and 44. Item number 44.
I'll come to the item. I am at the rule now.
Yes. Now, kindly come to me, Lord.
2K and 12.
Of 25 rules. Rule 4K. Interview list. In respect of SLST means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit. But every word, not the statute makers do not waste any word. That's the principle. To be called on merit for oral interview and lecture demonstration. Category-wise on the basis of preliminary merit. Therefore, you have to first fix up the preliminary merit, then invite them for interview and lecture demonstration. And what are the preliminary score? That is score from written test. The test for upper primary and traveling and academic score in the ratio of students. What is academic score? That is defined in, that is indicated in the advertisement. These are the eligibility clause academic score. Then after you prepare the preliminary merit, you call for the interview. Then final merit list. In respect of the SLST, a list of candidates prepared category-wise on the basis of merit, which will mean in addition, it's very categorical, whether the addition comes at this stage to what has been stated in the rule 21K. Marks obtained in oral interview, lecture demonstration, and prior teaching experience. Therefore, prior teaching experience, if at all, stand. The scrutiny of Article 1416 can only be considered after the preliminary screening is over, not before that. This is at the final merit stage. What they are doing, they are giving additional 10 marks to hoodwink the meritorious people at the preliminary stage. Though rule does not permit so. This is my very categorical submission, and kindly also come to me, Lord, the schedule. Milad, again, I would say, Milad, the statute makers, Milad, do not waste any word. Schedule 2, written examination, Weimar, then academics. Where in the parent rule, they say, Milad, academic. And why these academics? When you bring prior teacher experience, this is not really declared academic qualification. And you make it academics. Even assuming this is the part of academics, but this would not come when you are preparing the interview list. There 10 marks cannot be given, if at all can be given only at this stage of preparation of final merit list. To give them the handicap. That in our school days, when someone was a little weak, he was given a handicap for a flat race. Then you are given 10 marks of handicap when you are really suffering. At what stage? At the final stage, provided you come across on your merit from preliminary test, which many of them could not.
Academic score.
And yes, another word is very important, that is score. Merit score, academic score. Academic score, how it is asset? The educational qualification, 10 marks. And by percentage, you will get, if 60% above 10 marks, their merit score is mentioned. Below 60%, 8 marks. Below 50%, 6 marks. And what is the scope for scoring in teaching experience? The court is invited to give a harmonious construction and reasonable meaning. But unfortunately, I was shocked to hear that the authorities were arguing directly against their own rules. They said, no, 10 marks will go there. But the rule doesn't say so. Your own desire cannot change the rule. And like if your Lordship wants not to have the authority to show that this statute has to be read not in its entirety, even without one single word, one single letter has a meaning that has to be completely followed. Today I will stop here. 2016 পাবে না তো বলে there are authorities, I'm just not giving এটা দুটোর সময় এসে দেবো may I stop it?
All right, you want to come back at all right?
একটা বাজে আর পাচ্ছি কবে For us, kindly keep it on Monday.
All right. Let him make his submission.
Yes. But the other thing that I was suggesting, if somebody else, some other learned council wants to challenge the validity of this rule,
It can be done.
they may all argue together. Let them conclude, then we'll make our submissions. Number one. And number two, I don't know whether Mr. Bhattacharya is seeking any interim order or not.
No, I'm seeking you.
In that case, kindly give us a week's time to come back with affidavits.
No, but it has to be done by any means before 31st of December.
No, but the problem is that unless pleadings are your Lordship can very well appreciate it will not end over here. Therefore, the pleadings must be complete. We'll take the shortest possible time your Lordship feels for.
All right. You have the copy of the Supreme Court order, the last one.
Yes, the yesterday's one. Yes.
Yes, uploaded yesterday.
Yes, yes.
The last paragraph of the order.
Yes, madam.
Yes, adversely prejudice. Yes. As to what the High Court has to do, the court has mentioned.
Right.
Untainted candidates in the past selection are allowed to sit for the selection test to be held afresh. How do you accommodate them?
Is the candidate not
These are not in process.
How do you accommodate? You have set the eligibility score, the age in such a manner
Yes.
that some of the candidates are out.
Yes.
No.
Yes. Yes.
I like this. My learned friend has placed the rules in his own way.
No, in his own way. The age, as has been fixed in 2025 rules,
Yes.
right?
That is in terms of the Supreme Court's direction. Kindly have a look to the rules.
Hey, rules.
Yes. Please have a look to the rules. Take the rules.
Page 2025 tables. Page. Kevala. Okay.
Well, it's at page.
49 Para 49 of the Supreme Court judgment says age relaxation for the untainted candidates.
Yes, first, yes.
Age is taken care of.
Yes.
And then
Well, your Lordship may kindly take a.
order and then relax that.
So age relaxation is there.
Yes, para 49.
Score relaxation. Score relaxation.
Your Lordship may kindly take the rules.
Right.
Rule 3.
Right.
Is not for Malad, with deepest of respect, Malad, not for all the candidates. Who are the teachers? The candidate relaxation is not there.
Well, let there not be any piecemeal argument. I like this, your Lordship, in its entirety.
Yes, that is the last order. They're candidates, not the teachers.
Yes.
Let him answer.
Yes.
Yes, he'll answer
The
because
real
this
sufferer
is
is the whitelisted
direction of the court, Supreme Court on the High Court. So I just
Only the last paragraph may not suffice. The other orders are required to be placed before your Lordship. In bits and pieces, it should not be.
not in bits and pieces.
Because
There
all
are
the
matters.
all the
May not have
orders.
been served in all.
Sorry.
You may not have been served in all matters.
No, I've made myself ready in the first matter.
The very virus is challenged.
Yes.
Yeah, I understand. But their commission will be there. They'll answer regarding some of the candidates. I'm getting matters who have been, who are not in a position to even appear in the selection test because of the 25 rules. How will the court ensure that they appear? Keep in mind,
Very good.
this is what is playing through the mind of the court, relying on what the Supreme Court has directed. Prepare. Commission is also here. They will also prepare. All right. 2 o'clock.
2 or 3 things, primarily for the benefit of my learned friends, I'm submitting because on Monday they might add on to what they have said today. Number 1 is, Supreme Court has fixed a timeline which cannot be extended by the High Court. Number 1. Number 2, my 2025 rules may be bad. Then also, 2016 rule will not revive. Neither will the 2019 rule revive. Because 2016 rule was replaced by 2019 rule. Now 2019 rule is being replaced by the 2025 rules. Therefore, even if your Lordship shuts down the 2025 rules, then also 2019 will not revive, neither will 2016 revive. This is the second most important factor. The third most important factor is just the division bench judgment of Honorable Justice Shomenshen's judgment. Milord,
Urunima Paul and Dolui.
yes.
Yes.
Yes. These are, Milord, would be very 3 important aspects, Milord, on which, Milord, I will address your Lordship, subject to the other ancillary factors.
So, my lady will hear the respondent's side, untainted candidates on Monday. Is that the?
I do not know on Monday or not because the petitioner will start again at 2 o'clock.
Yes, my lady.
And the other petitioners also, I will hear them in one go so that the respondents can answer in one go.
For us, keep it on Monday, Milord.
Maybe
Provided they finish.
If they finish. Very good.
Might go to Tuesday.
All proceedings are live streamed. I allow visual appearances, virtual appearances. So in case you are not able to come down, you can join virtually also.
Being in my lady's court physically.
That is different.
Yes.
But then I cannot assure the timelines.
Of course, I follow.
This is the reason I just made my mind clear.
In the meantime, I also feel the prayer that made by Learned Advocate General that now there are repetitions. Now, at least there should be some pleadings on our part also.
Pleadings?
So that Lordships allows us
Affidavit?
Because I don't want it to be delayed in any.
Listen,
some kind of.
1 minute.
Yes.
The hearing is continuing.
Yes.
In case anybody wants to prepare an affidavit, please come. Hand over copies so that they can meet your objections.
Report, so that
very well. Because everybody knows the matter is not going to end here.
Correct.
Yes. Right, it's going to go up. So let the pleadings be on record. The court does not have any objection.
Yes.
But then keeping in mind the timeline that has been fixed by the court, I am continuing hearing. And in the meantime, you all can come up with your pleadings.
Yes. That's very fair. Thing, appearing for the commission. Now 18 is going on.
18 and 25.
18 and 25. I was just wondering, which of the matters the petitioners are going to make 18 and 25 only. No one else. One else from the petitioners.
One more.
As and when it comes up, take down note. Right now, only 18 and 25 has
been. One more technical aspect. The applications which are pending. Lordship may kindly have one formal.
You all have copies because all the copies are there in Sharthok. You all do have
that. That we have. That we do not need only one line so that if there is a requirement for us to go up, if there is a.
There will be.
Then, my lord, no.
Yes. Someone or the other will challenge.
My lord, because we are now, our technically our status is now, we filed an application, we are intervener and Lordship is hearing us.
I have mentioned in one of my orders that I am hearing now responding. Yes.
It might be.
I am hearing the intervention.
Yes. It might be interpreted that Lordships have not allowed us to be a party. And Lordships is getting that the effect of it, in case Lordship takes action against us, will be extremely harsh. So all I want, one sentence, the application.
In that case, all addition of party applications are to be allowed and formally added, and you can come up with your own pleadings.
Yes.
All right. Today this order will be passed after I hear. All the matters.
18 and 25.
Already 18 and 25.
Earlier day, all the order kept in Sarkar matter, that is 27.
All right.
I just my note says 18, 19, 24. 18, 19, then 27 is a 10-mark issue.
No, all issues are clubbed.
All issues, if it is being heard together, then those matters make me kindly club together and make comments hearing from 2 p.m. What I am respectfully submitting, all these School Service Commission matters are not same. Some of them will not assail the rules. Some of them say, when 10 marks are to be awarded.
That also comes within the rule.
That group may kindly be clubbed.
It is going on. It is going on simultaneously. Please take note as and when matters are called.
Only difficulty is my application are the entire series 18 to 44.
Yes.
Now we have filed applications in like 23, 25, 26, 27.
Let it be called on. Yes, Malik. Because even 23 implicates 10 marks. Previous means?
Issue
replace in respect of 2022 matters. But the judgment was delivered kindly ballot some matters so that everyone
now which will be the lead matter? You all have to decide. I do not know which is the lead matter.
18. Item 18. I beg.
27. I think everyone understood the basic issue.
Yes, the rules.
That we have.
Mr. Lahiri's matter is a different matter. He said no person His case is, untainted teachers claiming no contractual teacher should be getting any 10 marks. That is his case. Subject to correction. No,
that's a contractual.
Only, the 10 marks issue, if it is to percolate, contractual teachers should not get. That is what I have gathered. Item number 41.
41 my case.
If I am wrong, 41 is a different matter.
Contractual teachers, they are, my lord, that is no.
First decide whether 10 marks is there.
Decide whether the rule survives.
Yes, madam. Yes.
And if the entire rule goes,
then there will be no requirement to.
then
My point will be covered.
so let us wait.
Lordship, decide the
10 mark issue is there in the rule itself.
Yeah.
Right? So
Take that 10 marks.
Yeah, it's fine.
all right, I hear you all at 2.
Yes. My lord, I beg to mention, my lord, one. My lord,
We have a 3:30 today.
my lord, may I segregate one thing? My lord will remember the EWS issue. That is item number 24. My lord, from
Be
this
separate.
bunch, my lord, on
Be
Monday.
separate.
Monday, my lord.
Before.
No, 24 only. My lord, I beg to 24 on Monday, Mr. Pataji. My lord,
24 on Monday.
yes.
Item 24 on Monday.
Monday, because
All right, 24 on Monday.
my lord, and my lord. Yes.
Sir, do not repeat prayers. I have made what the court wants you all to know.
Yes,
24 on. My lord.
My lord, may I trouble your lordship with only one prayer? Your lordship might know, my lord, your lordship has been given the urgent determination of Justice Bhivash Pattanayak, my lord.
Yes, that is what I have signed in the morning.
By that,
My lord,
it has come to our knowledge. I could not have mentioned at 10:40 because it was not put to Sabha, my lord. There is one urgent matter. Mr. Bhattacharya, I have talked to my learned senior. He will not take 45 minutes.
45 minutes where? In this matter?
From 2 to in this matter.
All right.
He will conclude, my lord. Can it be little urgent? Last date is on Tuesday. It was heard by urgent.
Yes.
My lord.
We kept the.
Urgent determination based and I have to pass order today. It will not be possible.
Otherwise, my lord, matter become urgent determination.
The law has been settled by 2 coordinate benches as well as by the division bench. Whether pursuing candidates can
Participate in the selection.
participate in case. 100% is the last date.
Monday, you all can get it thrashed before the court.
Monday I will mention Tuesday it will be taken up.
I'll direct the matter to be there in the list on Monday at the top and mentioning your urgency so that the court can take it up on Monday.
Implement the urgency because I have already settled.
Well, just to be listed, your lordship only passed that order.
All right.
I just give the number.
This will come up in the supplementary list today.
Oh, person.
Supplementary list.
Malad Justice Pattanayak's.
1 minute. Supplementary. 325.
My lord, I have.
Grateful, Malik. Where is the file?
My lord, file kept in 770. My lord, I just get the number, my lord. Especially my lord, I too am mentioning one matter of Justice Pattanayak's. My lord, I can speak to this. My lord, extension, my interim order will expire on 30th, my lord. Today, my matter was on item number 3, my lord. My lord, by the time the notification came, my lord, sat, my lord, I could not, my lord, mention. My lord,
You can get it done on Monday only.
30th, my lord, I am getting script of my interim order, my lord.
My lord, extension of interim order to DNA.
না না আমি ডিটেইলটা দিলাম এটা মেনশন
The other side should be here.
দিয়ে দেবে মানে সিমিলার ম্যাটার দ্যাট ইজ মিস্টার ভট্টাচার্য মিস্টার দাসগুপ্ত স্পেশাল এডুকেটর জিজ্ঞেস হাসান মন্ডল ম্যাটার মানে মিস্টার দাসগুপ্ত and I did
Justice Patanayak.
Yes, madam. Yes, we both were argued in that matter. Monday.
বলে দেবে মানডে
My lord, item. One minute. Are the matters in the list?
Yes.
Item numbers.
Item 2 in item courtroom number 17, item number 6, item number 33 in Mr. Honorable Justice Basu's list, my lord.
I do not have the determination.
No, my lord, today Honorable Justice Basu is not sitting, my
But
lord.
then I do not have Justice Basu's determination.
No. Urgency determination. And today, urgent whatever.
अरे वहीटा ना वहीटा
आगे चेक करो हाँ ये तो अर्जेंट डेटाबेस अभी हॉश फोटो है Justice Basu
this
not
mother.
the- Court.
17. Item number 7 and 33. প্রথমটা 7 আর item number 33.
দেখে করবেন
Your Lordship. My Lord. My Lord.
Item number 7 and 33. No, 7 is sorry, 6. Sorry, pardon me, 6. Raju hence. একটু বলে দিই আমি 6 হ্যাঁ 6 হ্যাঁ না 33 আমার 33 আছে ও But because this is
only
club.
direction will be
Item number-
that the matter
item number-
will appear before Justice Patnaik on Monday.
একসাথে আছে
I will only place the matter in the list.
কাগজ দেওয়া আছে
আজকে নিয়ে এখন
But if the matter is already in the list, then what?
But the urgency is that the last date.
On merits, I'm not going to take.
Wait on Monday itself.
How can we do it on Monday when our country is
already simple.
as an urgent determination matter.
Right.
Then I have to mention it on Monday for Justice Patnaik.
So you want
Your lordship was around
no determination. Five.
I'm only reminding.
My Lord.
Not on merit.
Item number
not
3.
on merit.
3.
My Lord,
Number
item
17, item number
23, my Lord, to be clubbed together with 18 and 25, your Lordship's list. Mr. Bhattacharya had been appearing in item 23 as well.
The matters are being taken on one by one. Just remain.
Point interjection, Your Lordship. The item number is 111, Your Lordship. If it is not heard today, the order will be in fact. The second SLST examination, Your Lordship, there is a category change in general. The already Your Lordship heard yesterday. That senior Pratik was argued on this matter. Your Lordship passed the order, Your Lordship. I am in the same meeting. I am also reserved that we can.
Has the order been put up in the server?
No, not yet, Your Lordship. Kindly fix it to 2 p.m., Your Lordship.
2 p.m. It's impossible. Let the order be put up in the server.
See, Monday is the verification day.
Oh, today I'll take it up.
The deficit.
Who's the commission must be there?
Yes, Your Lordship.
The commission
is the junior.
What is your name?
Lordship Danish. Mohammad Danish Faruqi.
All right. Which item?
You don't know 111.
Please take note. Possibly one order was passed yesterday regarding the
WPA 26937 of 2020.
একটু দেখুন তো আমি দেখেছি কালকে
26937 of 2025. Same order, Your Lordship. Grateful.
My lord.
But কি হয়েছে?
But although it's a recess time, my lord will.
একটা মিনিট
All right, let me
My lord, item number 12. Item number 12, the CBI came here at 1 p.m. On 1 p.m. They says that before recess that take instruction from SSC, the CBI. Because CBI is the party in the item number 12, the OMR sheet issue.
Wait, let me assimilate myself. Confused.
এখন ঠিক আছে এখন মানে by that for the deficit court fee otherwise the order will not be signed possibly item 14
today's item?
Yes, your lordship said that unless I pay the deficit court fees, it will not be.
Under pressure and they'll work.
No, I do it. I usually do it. Reverse by the court fees জমা করেছি তার কাগজটা।
Yes. Yes. এটা নিয়ে নিন।
It has to be it has to be in the file of your lordships. 14.
I fit.
Yes.
Yes, server is. Yes, which item you said?
Item number 12, my lord.
12.
I place that matter, my lord. The OMR sheet is not.
Candidate.
Right.
If I may, if your lordship noted,
ধরার আগে একবার just আমায় ইনফর্ম করে দেবে। Anyways, I'll be here from 10 p.m.
Or rather, OMR it was never uploaded the commission website. Now, when this
listen one thing. It is your data which has been forwarded to the commission and published. Right? What data do you have in respect of page 42 where the petitioner's OMR is blank? This is the only candidate out of the 3,000 candidates.
470.
Right. Serial is appearing as 2442.
Right.
Where the numbers is been mentioned, it's not even zero, lordship. It is completely
blank. What does this blank mean? Where is his?
Has been what instruction which I have received from my officers is that possibly this is an error.
What error on your part?
No, at the end of the commission.
What is error?
Because my instruction says that he has attended, good, bad, indifferent, he has attended some marks, he has attempted certain questions.
Do you have written instructions?
Lordship, I do not have. If your lordship so directs.
Can I record your oral instruction?
Lordship, if your lordship so directs, I can produce it on Monday, lordship.
Monday, produce it. That's the suffice.
It is the OMR sheet.
You can produce the OMR sheet. You have copies. Very well. That's good.
That's the suffice,
one thing which I would like to bring it to your lordship's kind notice that despite several opportunities being rendered to all candidates across, whether tainted, non-tainted, when the Honorable Division Bench of this Honorable Court presided by Justice Basar was in season of the issues of the matters, there all candidates were rendered opportunity of inspecting their own OMRs.
Physical inspection of OMRs.
Inspection of OMRs at the chamber of the Advocate on Record of the CBI. Lordship, despite that particular issue has been completely silent in this particular writ petition, whether he has applied for it or not, and whether he was rendered opportunity or not. So this is possibly what I am trying to establish before your lordship is that this is one of the loopholes of the petitioner himself, and he cannot claim.
With deepest of respect, my lord.
Advantage out of it. Right. I get it. Nevertheless, since you say that you have a copy,
yes,
please produce that on Monday. All right. Please come.
If your lordship can kindly direct so.
I'll direct. Item 12. Item 12?
Yes, my lord. Item.
ঠিক আছে. The petitioner participated in the RLST bracket NT, 2016 for Group C post. Though his name.
I have received instructions from the School Service Commission in this item.
Yes.
The public being
But in item 12, I am appearing for the commission.
Right. What is the submission? Commission your submission, please, in item 12.
But may I indicate one thing because that will help the court. But in division, Honorable Justice Devanshu Bosak's judgment, my lord, in para 363, para 3, my lord, that is specifically mentioned that OMR sheet available in the 3 hard disks, if not already done or such portion not done, must be. Rahul, your voice is cracking.
Incomplete.
Why don't you take instruction?
But for this candidate, my lord, we have received incomplete OMR sheet from CBI. Am I audible, my lord?
Incomplete OMR sheet. The CBI has the OMR and it will be produced in court. Acha. Okay. Though his name, comma, serial number, comma, roll number, published OMR marks.
There is some network issue, my lord. We have received instructions with this
marks.
we have received the OMR sheet of this particular candidate.
West Bengal Central
OMR sheet is
in compliance of the Commission on 13th March 2023, in compliance of the direction passed by the court on 10th March 2023 in WPA 12270 of 2021, the actual OMR marks is not reflected in the said list. Stop. The learned advocate representing CBI submits upon instruction that the OMR of the petitioner is available with the authority. Stop. Let the same be produced before this court on the...
May I make one submission, Milord?
First.
Milord, for this candidate, Milord, we have received a cropped copy of the OMR image from the Commission. I am instructed that this is the copy which was furnished by the CBI with regard to this candidate. Milord,
the CBI will produce a copy.
One thing, I just indicate one thing because of that, Milord. Because on that 13 March, in respect of 13 March order, OMR sheet is not uploaded of this petitioner. There is a specific, because that is the interim order for that advocate on records office. They can, but the final judgment, there is a, in subpara 3, there is a specific direction upon the SSC. I just read it for 3 lines. Para 363, Honorable Justice Devanshu Bosa's judgment, my lord. OMR sheets available in the 3 hard disks, if not already done or such portion not done, must be uploaded in the website of SSC forthwith and made available to the public for viewing. Till date, 2016 OMR sheet is not uploaded in the website.
Past order for...
That is 2020 in respect of 2025. Malad, because of that, why it is necessary? For 2 reasons. Why I make it... Why this is two reasons? Because of that, in this selection process, 2020 selection, 2025 selection process, there might be some candidate who even beyond the SSC's assessment, there might be tempted. What the reason of the uploading of this OMR sheet? The reason of that, transparency. But SSC not yet published it. Why? Because they want to hide it.
Right.
So they give the passage. First they try to give passage to the tendered candidate.
All right.
So my lord, it will be kind enough.
No,
judgment is there.
One minute.
Upload. My lord, the direction of this...
The OMR in the public domain, have you uploaded the OMRs?
Milord, there was no such direction to upload OMRs from your lordship's order. The direction to upload OMR by the division bench, Milord, it merged with the Supreme Court's order.
Yes, Supreme Court order.
There was no such direction to upload OMR. There was a direction to publish the tainted list. Milord, we are trying to upload the OMR of 2025 SLST pursuant to your lordship's last order, Milord. And that OMRs were also uploaded pursuant to the directions of the erstwhile division bench's order, Milord, until it was set aside by the Supreme Court on 8th of November.
With the greatest of respect, my lord, I want to give para 45, my lord. Para 45, my lord.
Milord, the current division bench has admitted that the order has merged with the Supreme Court order in the contempt proceeding, Milord.
It is merged in Supreme Court order.
Provided the time of the court permits, it will be taken up. The matter is there in the list.
Continue for us.
Beautiful.